Let's talk about this motion that was filed by former officials in 5 Republican administrations, dating back to Richard Nixon through George W. Bush. All these officials joined together, filed this motion to bring what's called an amicus brief, where they want to oppose Donald Trump's appeal of the Washington, D.C. federal Judge Tanya Chutkan's denial of Trump's motion to dismiss the Washington, D.C. criminal indictment on absolute presidential immunity grounds. You will recall back on December 1st, federal judge Tanya Chutkan denied Donald Trump's motion to dismiss the indictment on absolute presidential immunity grounds. Judge Tanya Chutkan ruled that there is no absolute presidential immunity for former presidents in criminal cases. Donald Trump then on December 7th filed a notice of appeal to the D.C. Circuit Court of Appeals, as well as a motion to stay. Special counsel Jack Smith then filed a motion to expedite briefing before the D.C. Circuit Court of Appeals. They set a very tight briefing schedule on Jack Smith's motion to expedite. Special counsel Jack Smith then also went directly to the United States Supreme Court, said that the appeal that's being filed by Donald Trump asserting absolute presidential immunity is of such an extraordinary nature that the Supreme Court should hear this directly before any ruling is even entered by the D.C. Circuit Court of Appeals. The United States Supreme Court granted expedited briefing on the issue of whether they should hear oral argument, what's called granting certiorari. Donald Trump has been ordered to respond on the issue of whether or not certiorari should be granted by December 20th. In other words, whether oral argument should or should not be heard by the Supreme Court. So now, though, this group of former top officials from 5 Republican administrations, they want to file what's called a friend of the court brief, or in Latin it's called an amicus brief, where there's a way that groups that have special interests in a case can file a motion like they're doing here for leave to bring a brief that is just something that could be persuasive for the court. It's not binding on the court. This is not a party to the case. It's just submitting a brief of, hey, this is a group of influential people. Court, we want you to hear our take on it. The court doesn't have to read it. The court doesn't have to cite it because these are not parties to the case. But when you have a group like this, a who's who of people from former Republican administrations, and we're talking about top people from the DOJ, top Republican officials, and people who support a strong presidency, people who have even been, talking about the unitary executive doctrine. They're all saying, whoa, 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 hold up. What Donald Trump is requesting here, absolute presidential immunity in a criminal case, we don't care if you're a Republican, independent, Democrat, whatever. Donald Trump is arguing for a dictatorship, and the United States Constitution does not support that at all. Stop right now. And that's why this group of former top Republican administration officials, former top Republicans within the DOJ, Republican scholars, they're coming together and saying, look, we're Republicans. This isn't a political or partisan issue. This is the Constitution, damn it. And that's this brief that was filed, this amicus brief, and this leave to file this amicus brief by all of these former top Republican officials. Just take a look at this list. It's a who's who. In the appendix, Donald Ayre, John Bellinger, Barbara Comstock, John Danforth. I mean, we're talking about top Republican officials, state representatives, DOJ officials, Mickey Edwards, for example, representative of the 5th Congressional District of Virginia, Charles Freed, the Solicitor General from 1985 to 1989, the person who argued before the Supreme Court in the Reagan administration. You've got Stuart Gerson, the acting Attorney General, John Garrido, Attorney Advisor, Pete Kessler, acting attorney general in 2007. You got Michael Ludwig, of course, the main conservative right-wing judge. You've got Alan Rowell, Paul Rosenweig, Deputy Assistant Secretary for Homeland Security. I could go on and on, but these are the top people, the top legal thinkers, the top scholars, the top DOJ officials, top congressional representatives, all Republicans, all of them. And we're talking about over a dozen of them coming together in this brief. So let's take a look at what they're saying in this brief, because it is profoundly, profoundly important and impactful. And they say, look, Judge Tanya Chutkan got it right. She recognized that there shouldn't be absolute presidential immunity in criminal cases, period, full stop. And one of the things that are cited in this brief as well is this group of former top Republican officials say, also, don't forget, D.C. Circuit Court of Appeals, what another panel just did a week and a half ago in the Blassingame case, where they found that Donald Trump was not entitled to absolute presidential immunity in the context of civil cases, that his conduct relating to January 6th and his attempt to overthrow the results of the 2020 election, that falls outside the outer bounds of presidential authority because it was election activity. So there's multiple reasons right here, D.C. Circuit Court of Appeals. Number one, it's what Judge Tanya Chutkan said. There can't be absolute presidential immunity in a criminal case. All that would do is inspire dictatorial presidents who would not be presidents as envisioned by the Constitution, who would then even try to take the military as a way to seize power and claim that they're absolutely immune from it. Here, take a look at this argument. If you go to page 19 of the brief that this group submitted, they said, under Trump's view of absolute immunity, a future president could disregard current criminal restraints against using the military to alter election results. Talks about how special counsel Jack Smith's indictment alleges that Trump's attempt to use the Justice Department to make knowingly false claims of election fraud to officials in the targeted states through a formal letter under acting attorney general's signature that urged the targeted states to replace legitimate Biden electors with defendants. The former president has argued these were official acts because an attorney general is appointed by and reports to the president. But under this reasoning, armed with absolute immunity, a future president would or could be incentivized to enlist the Secretary of Defense to deploy the military to support efforts to overturn a president's re-election loss. Just like the Attorney General, the Secretary of Defense is appointed by and reports to the president. So they're saying if you carry Trump's argument to its next logical conclusion, it's illogical because he's saying that he can have a coup and then cite absolute presidential immunity. And look, in the very beginning of this brief, these group of officials say, look, we support a strong presidency. This is the group that was arguing for the unitary presidency. But they say, reflecting on their experiences and with an interest in a strong presidency, they all are saying a strong presidency doesn't mean a dictatorship. And that's what Donald Trump is requesting here. The brief goes on to talk about how one of the factors on which the district court Judge Tanya Chutkan's decision relies was that it would, quote, betray the public trust to give a former president categorical exemption from criminal liability for attempting to usurp the reins of government. This brief demonstrates that this ground by itself provides one of the bases to affirm. And if there's just one basis to affirm, that's it. Let's be done with it. Put Donald Trump on trial on March 4th, 2024. And then goes on to talk about what's called the executive vesting clause in the United States Constitution. And if you look at it, Article 2, Section 1, Clause 1 of the Constitution provides the following. The executive power shall be vested in a president of the United States of America. He shall hold his office during the term of 4 years, and together with the vice president chosen for the same term, be elected as follows. This executive vesting clause creates the only presidency we have under our Constitution. The second sentence of the clause requires a first-term president who loses re-election to leave office at the end of his term. This was an important selling point during the ratification of the Constitution at the Constitutional Convention. And under Donald Trump's view of absolute presidential immunity, it would vitiate the whole purpose of this Article 2, Section 1 clause, the executive vesting clause, because he could try to do an end run around the clause and then claim absolute immunity. So inherently, based on Article 2, Section 1, there's a textual justification as well, this group wants to point out to Judge Tanya Chutkan, that hasn't been addressed yet, where clearly the Constitution itself rejects absolute presidential immunity in a criminal case through the executive vesting clause. And I think that's one of the key points here that this group of former top Republican officials also wanted to add, because Judge Tanya Chutkan's analysis was brilliant, folks. I mean, the structural, the textual, the historical analysis of the Constitution that she did was chef's kiss. Beautiful, but she did not touch upon this one other argument on executive vesting clause, and that textual argument that's brought home here by this group of former Republican officials. And she also didn't really focus on the D.C. Circuit Court of Appeals decision in Blassingame all that much, which came out right around the time where Judge Chutkan issued her order, which bolstered her order. As I said, it's like double protection for Judge Tanya Chutkan's order, in the sense that Judge Tanya Chutkan's saying that, look, there is no absolute presidential immunity. That concept exists. I understand in civil cases, in a case called Nixon v. Fitzgerald, where there was a wrongful termination lawsuit, there was this concept that the Supreme Court recognized in the early 1980s when that case was heard, that former presidents or presidents for acts that are in the outer perimeters of presidential authority, in that case hiring and firing employees, do get absolute presidential immunity in civil cases. But what the D.C. Circuit Court of Appeals held in civil cases relating to Trump is that Trump's conduct was beyond the outer bounds that was allowed in the Nixon v. Fitzgerald case, because Trump's conduct has nothing to do with Article 2. It has nothing to do with being a president or a commander-in-chief. It had all to do with the election. So that's kind of protection area 1. First level of protection. In civil cases, the D.C. Circuit Court of Appeals is saying there is no absolute presidential immunity for Donald Trump in connection with January 6th and his related conduct there too. So if that's the case, then clearly when it comes to criminal conduct, criminal allegations, that would fall outside the outer bounds of presidential authority. And as Judge Chutkan said, that whole doctrine of absolute presidential immunity doesn't apply. So here, this group of former Republicans is saying to the D.C. Circuit, hey, remember your ruling in Blassingame that even if you have this doctrine of absolute presidential immunity, it does not apply to Trump because Trump's conduct was election related. So that's number 1. Number 2, you've got what Judge Chutkan ruled: absolute presidential immunity does not apply in criminal cases. And then number 3, let's look at the text of Article 2, Section 1, Clause 1, the executive vesting clause, and that gives you yet another textual justification about why there can't possibly be absolute presidential immunity. So again, this is former Republicans, dozens of them, who joined together to write this. Top judges, top officials, dating back to Nixon. That's why I always like to say here, this is not Democrats feeling this way, Republicans feel this way. No. There's this MAGA, unlawful, rogue authoritarianism, and then there's our legal system, and that's pro-democracy community of actual Republicans and actual conservatives and Democrats can join together and go, this is it. This is basic. This is foundational. It is. Anyway, thanks for listening. As I geek out here, hit subscribe. We're on our way to 2 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch and have a great day.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.